the new developments in the Karen Reed murder trial.
This has been a wild turn of events.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
It's a spectacle, that's for sure.
It was a hung jury, so no verdict, no real ending to this case.
Karen Reed was back in court where a date was set for her to be tried once again.
There are a lot of issues in this case.
Proctor was improperly searching Karen Reed's cell phone for nude photos.
Michael Proctor, the lead investigator,
relieved of his duties.
It's always the theories that each side will put forth for a jury to decide which one is more believable.
Karen Reed was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
Karen, did you ever say I hit him?
I did not.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
and once again, there was drama outside court.
There is a whole new set of legal troubles for Karen Reed. She is now facing a wrongful death lawsuit.
The lawsuit alleges that Karen Reed was drunk and reckless when she hit John O'Keefe.
It's not just Reed being sued here. The family also suing the two Canton bars from that night.
The two bars are liable for over-serving her.
The FBI is investigating an investigation of a murder. That never, ever happens.
At this point, multiple jurors have been reaching out to both sides, saying that they are certain Karen Reed is not a killer.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
There are 17 jurors, and they are coming and going with a police escort.
The investigation wasn't thorough.
This can't be good for the prosecution moving forward.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
The last 3 episodes have primarily dealt with some of the craziness that has been happening around the perimeter of the trial against Karen Reed for the death of Officer John O'Keefe. For those who have been following along with the Turtle Boy saga, some of it may not have been new information, though some of it had never before been discussed by Carney. For those who haven't followed along with the perimeter noise, you may be wondering why the detour from the updates that I'm usually covering about the Reed trial. Well, in this week's episode, you'll get your answer. There are a few things that we have to go over this week, but one of those topics is directly related to the Bedrow letters and the information that I provided in the last 3 episodes. The defense team for Karen Reed has filed a motion requesting the personal correspondence of Norfolk District Attorney Michael Morrissey, and in the motion, they reference the Bedrow letters and Morrissey using his personal email address to communicate ex parte with Stoughton District Court personnel and judges, and using his private cell phone for improper communications with the court and witnesses. Also, in episode 30, I mentioned the Commonwealth filing where their expert believes that they should have acquired 2 gigabytes of data from Karen Reed's car. But that would be 16 gigabits, and the car chip was only 2 gigabits. That math wasn't mathing. Well, as it turns out, the defense has another filing that points out this error from the Commonwealth. And they're arguing that the prosecution's new expert lacks basic understanding when it comes to the analysis of the extraction of the data from the infotainment center. There are other filings as well, and we'll get into all of those and recap the hearing where each side argued their case. Also, an update on the civil hearing and a ruling that was made about that, the arguments in front of the Supreme Judicial Court about dismissal of charges based on double jeopardy, and a 2-part Vanity Fair profile on Karen Reed that revealed some never-before-heard information. We have a lot to cover, so let's jump right in. Let's start off with an update on the civil suit. As we've mentioned before, the O'Keefes have filed a wrongful death suit against Karen, C.F. McCarthy's, and Waterfall. Karen's retrial is currently scheduled for January, and she's requested to delay the civil suit, arguing that her Fifth Amendment privilege against self-incrimination would be impacted if the wrongful death case proceeds while the criminal prosecution is ongoing. C.F. McCarthy's and Waterfall also want the civil case to be delayed to, quote, preserve the resources of the parties and witnesses and promote judicial economy, end quote. The O'Keefe family opposed the case being delayed, arguing that there would be degradation of evidence and that witnesses may have fading memories or become unwilling to cooperate over time. On Halloween Day, Justice William M. White Jr. issued a ruling on the request, and it was a win for Karen Reed. In the order, White said that participation in the civil case poses the danger to the defendant of an increased likelihood of a conviction at the criminal trial by self-incrimination through exposure to cross-examination. Now, it's the court's job to balance the competing interests at stake. And while he acknowledges that the O'Keefes want to move forward with the civil case now, he says that delaying it by 6 months is reasonable and there would be minimal harm to the O'Keefes by doing so. However, by not delaying the 6 months, Karen would face great potential harm because she would be forced to defend herself in the civil case while also fighting criminal prosecution. White says that the most important thing to consider is the potential impairment of Karen's Fifth Amendment privilege against self-incrimination. Now, he acknowledges the arguments that the O'Keefe attorney made, claiming that Karen speaking to the media contradicts any suggestion that she is concerned with self-incrimination. And White says, however distasteful that you may think it is for her to speak to the media, it doesn't mean that she's waiving her Fifth Amendment rights. White says that the prejudice to Karen from having to choose between defending herself in the wrongful death case and protecting herself from criminal prosecution outweighs the estate's interest in getting an expeditious resolution of the wrongful death case. So, the case can continue on, but all discovery directed toward Karen is to be delayed pending resolution of the criminal trial. Next up, updates on the appellate process. There was a hearing this month where the Massachusetts Supreme Judicial Court, or SJC, heard arguments from both sides on the dismissal of 2 of Karen's charges, as well as whether or not the jurors in the first trial should be questioned about whether or not they reached a verdict. Now, this hearing was incredibly interesting to watch. Look, I enjoy watching the justice system in action. Sure, real-life court proceedings are not what you see on TV and in movies, although every trial does seem to have some of those moments for sure. But in the real world, you may sit through hours of tedious questioning because the constraints on how things can be asked and how things can be answered, that process slows everything down. So the whole idea of getting information, or at least getting enough information to give the full picture or tell the full story, it can be really long and drawn out. And that's part of why this podcast does so well. I get the information and I put it together for you. But the appellate courts are totally different. I mentioned the difference in styles of Karen's defense attorneys, Jackson and Yannetti, compared to the appellate attorney, Marty Weinberg. Jackson and Yannetti are brilliant and talented lawyers. There's no doubt about that. And so is Weinberg. But their styles and their strengths are so different. Yannetti is the hometown, relatable, and likable attorney. Jackson is the charismatic storyteller that keeps a jury hanging on to every word. And Weinberg is calm, confident, and basically a walking law book because, man, is he able to cite case law and explain his position in a way that's incredible. It's unbiased, factual, based on logic, law, and the Constitution. Also, the whole process of the appeals process in general, it's an art form. Being able to analyze the trial and find issues that give a basis for appeal, and then writing the brief, which itself has to be so exact and well constructed. Then giving the arguments in front of the SJC. It's not like getting up there and reading your book report that you wrote. These justices are well versed in the law, and they've already read the brief, so they know what the brief says. They want to ask questions, so they interrupt and they quick fire these questions at the attorneys that they have to be ready to answer and back up their position. It's incredibly intimidating, but hearing the back and forth and the legal considerations behind every part of this, it's really incredible to watch. And the arguments are timed. You're limited, so you have to reduce the entire argument down to the bare essentials and be ready to defend your stance as you maneuver through this complicated area of litigation. It's really great to see. So, having said all that, Let's talk about what happened during the oral arguments in Karen's case in front of the SJC. Weinberg begins by bringing up the jurors who reached out to the defense and the prosecution about the unanimous decision to acquit on 2 of the charges. At only 1 minute in, the first interruption already comes when Justice Gabrielle Wolohojian stops Weinberg and asks about clarification on the number of jurors who they are saying reached out. Now, I'm not going to go through the entire hearing word by word. We already know the defense's stance, but I want to talk about what questions the justices had and what the responses or arguments were. So the first question was Justice Frank Gaziano asking how you can consider this an acquittal without a verdict in open court and no verdict slip. Weinberg says that he's not asking the court to just impose the acquittal. He's saying that there is a unanimous decision that was made by the jury that can be proven through a jury voir dire. Gaziano says juror voir dires are limited to extraneous information given in front of a jury. So he asks if Weinberg is asking them to carve out a new exception. Weinberg's answer here was spot on.
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude.
I love the wording of that. Inflexible rules that would expense justice. And this is a very unusual situation, but it's not necessarily carving out a new exception. It's instead giving an extension to an already existing one. Gaziano then asks about this inquiry to jurors intruding on the sanctity of the deliberative process. Now, this is something that we've heard the Commonwealth argue before, and I've said before my stance on this is pretty clear. They aren't asking about the deliberative process, just the outcome. Weinberg gives this argument and says the inquiry would be not about why they voted that way, but just if they voted that way. Gaziano then asks if this is to impeach the written communication from the foreperson, who said that they couldn't reach a unanimous decision on the charges. Weinberg gives the argument that it was ambiguous, which is an argument that I've also given in previous episodes. Justice Scott Kafker cuts in and asks about everyone being on board with the mistrial when it was declared. Gaziano asks if they could have brought up being against a mistrial during the time of scheduling after the judge sent the jury out. So basically, could the defense have said, hey, we don't want a mistrial? But Weinberg says at that point, it would have been futile because the jury was already dismissed. The conversation turns to the defense not objecting. So basically, why didn't they object when she called the mistrial? And also agreeing that the jury had exhausted efforts that were asking for the Tui Rodriguez charge to be read. Now, Weinberg argues that pushing for the charge to be read is not pushing for a mistrial, but instead it's pushing for the charge to be read, which the whole point of the charge is to encourage the jury to go back and reconsider their positions to see if they can come to a unanimous decision. That point is huge. That's something that the Commonwealth has argued multiple times, that the defense was fighting for a mistrial and they wanted a mistrial. But they weren't. What they kept asking for was for the jury to have the Tui Rodriguez charge read. And the whole point of that is to hopefully get them to come to a unanimous decision. Justice Sergei Georges Jr. asks about deliberations not being completed. So does that allow for the jurors to change their mind because they may have gone back and changed their vote based on their decision for count 2? Now, we heard repeatedly that that's not the case. They stopped voting on those 2 counts because they all already agreed on those. As the panel is firing questions at Weinberg, he masterfully cites case law. He knows it really well. It's very impressive. He makes his oral arguments, thanks the panel, and then it's time for the Commonwealth's appellate attorney, Caleb Skillinger. Now, he's asked about the third note from the jury being different from the first 2 because Judge Canoni didn't speak to the attorneys on each side before bringing in the jury. With the first 2 notes, she got the note and then spoke to the attorneys. But with the third one, she didn't give them a chance to speak. She just brought the jury right in. So since she didn't give the attorneys a chance to speak on the third and final note, they want to know, doesn't that make this different? Well, Skillinger responds that it was inevitable that the final note was going to result in a mistrial and says that the defense would have believed that as well. So Gaziano asks if the judge had an obligation to ask the jury about the impasse being on all charges or being partial. And the answer to that is no, there was no obligation. But then he asks if the judge has the discretion to ask. And the answer, an answer that Skillinger didn't sound like he wanted to give, is yes. And what that means is that if the judge has the ability to ask at their discretion, then by law, that means that it's not coercive to ask. She's legally allowed to do so. Justice Georges asks about manifest necessity, meaning a circumstance that is so overwhelming that reaching a fair result is impossible and a mistrial must be declared. Now, he points out that the third note would have been the most important one to ask the attorneys about and give them the opportunity to speak on because they have gone through such a long trial and spent so much time and energy and money and anxiety and angst all to try this case. So he says, wouldn't it make sense? Wouldn't it make the most sense for the judge to give the attorneys the opportunity on this note before declaring a mistrial? Skillinger agrees that in hindsight, it would have been a good thing to do. But because of the defense's response to the first two notes, he says that Canoni would have likely assumed that the defense consented. Now, Kafker points out that if you don't ask, consent is out the window. That's a really big point. Skillinger says that each time that the defense argued for the Tui Rodriguez charge to be read, they were essentially pushing toward a mistrial. Now, Kafker responds with the same argument that I've been saying, but as a justice who is much more versed in the law than I am, he also says it much more eloquently.
But pushing towards a verdict is different from, that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Skillinger argued that it would not be appropriate to conduct a post-trial inquiry at this point for a number of reasons. The first one that he gave was that the jury has been discharged for 4 months. But Gaziano points out that under the guidance of case law, that they actually are able to bring the jury back. Then he sums up very simply what Weinberg is arguing and asks Skillinger for his take on it.
What Mr. Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike...
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
It's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of two competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an interest in a just judgment that is, in fact, a final outcome or final verdict here.
Skillinger then argues that asking for a snapshot of part of the deliberations doesn't give the full picture, and he says it should be denied. Now, the reason that this is so different is because this is the first time that there are jurors saying, hey, we reached a verdict, but nobody asked us about it. This is all new, so this would require the SJC to expand on that case law, on the exceptions that are already in place, and basically forge a new path for a new situation. The SJC will make a decision, but they've been known to take their time, so not sure yet on when we will hear from them. As always, I'll keep you posted. We'll be right back after this. The Karen Reed case updates keep me busy, and I was streaming the latest hearing on my YouTube channel recently, and I told y'all about Magic Mind. I actually drank mine while I was live waiting on the hearing to start. Magic Mind has been a huge life changer for me. My schedule is crazy busy and I'm working on multiple projects at once, so there always seem to be distractions and it can be incredibly stressful. And it's hard to get everything done when I need to. But what if we can be more efficient while also having a less stressful day? Magic Mind is a mental performance shot. You add it to your daily routine and it gets you focused, mentally clear, motivated, and productive, reduces stress, and it has over 100% of your daily vitamin C and D per bottle. It's not a quick fix. The ingredients can take 3 or 4 days to take their full effect. So each day you feel better and better. And it doesn't replace coffee. So if you need your daily cup, you can still have it. This is an addition to your regular routine. But also, caffeine doesn't actually give you energy. It blocks the receptors in your brain that tell you that you're tired. So when it wears off, you can feel that caffeine crash. But with Magic Mind, you don't have that. The 12 active ingredients support your body's energy engine instead, day after day. And Magic Mind knows what they have. They're confident in it, so there's no risk. They offer a 100% refund, no questions asked, for 100 days after buying. You have a limited offer that you can use now that gets you up to 48% off your first subscription or 20% off one-time purchases with the code JUR20 at checkout. You can claim it at magicmind.com/jur20. Another topic making headlines recently is the 2-part profile of Karen Read that was published in Vanity Fair. The profile is based on an interview that Julie Miller did with Karen over the course of 3 days while staying in Karen's home with Karen and a security person who Miller describes as a John Cena lookalike. Karen described it as the strangest sleepover ever. Miller says that Karen keeps a Ziploc bag ready in case of sudden arrest. The bag contains Advil, melatonin, toothbrush and toothpaste, hairbrush, a strip of paper with her lawyer's number, and some foundation and lipstick. She said Karen also has a burner phone and SIM cards, purchased after she found out that the authorities were tracking her this year. Karen told Miller that there were no questions off limits. There was nothing that she was afraid of, and any question that Miller had, she had answers for. Karen gave her version of what happened, which is much of what we've already covered in previous episodes. She dropped him off, went home, and woke up upset because he wasn't home. Then she described going back the next morning when she found John on the side of the road and the spectacle of emergency vehicles racing onto Fairview moments later. But something that was really interesting here, Miller actually spoke to a neighbor of the Alberts who snapped photos of the scene that was happening outside. The neighbor told Miller that the Alberts saying that they slept through all of that commotion, quote, absolutely doesn't make sense, end quote. Karen recalled the events of the morning, going to the hospital, her conversation with her father, and finding out that John was dead. Miller said that after leaving the hospital, when Karen went to John's house where his family was, she asked them what John looked like when they went in the hospital to see him. Paul's response, according to the Reeds, was that he looked like he went 5 rounds with Mike Tyson. Peg, John's mother, had a different assessment. She said that she thought he looked like he got hit by a car. Now, in the moment, Karen said that she felt hostility from John's family that she wasn't expecting. So she and her family decided that it was time to leave. Karen and her father went upstairs to pack her medicine and some of her belongings. She said that she hugged and kissed John's niece and nephew for what would be the last time, and then they left to go to Karen's parents' house. When they left, Karen told her father that she felt like John's mom blamed her for John's death. Days later, Karen received the court order that she was no longer allowed to contact the O'Keefe family. Karen became the one and only suspect, and she was arrested 3 days later. She told Miller that a cousin who had a criminal record called her and warned her that she needs to question everything. He said that he pled to a crime that happened when he wasn't even in the state at the time, just so he could get out of jail. And he told her that they don't care if they have the right person behind bars, as long as they have someone. Again, question everything. When Karen's charges upgraded from manslaughter to murder, she was rearrested, and Yannetti said that the second arrest was dirty and underhanded. To be rearrested, it usually means that there is new, compelling evidence. But in this case, there was basically just the interviews with the kids where they talked about John and Karen arguing sometimes, and Karen's blood sample from the hospital that the Commonwealth used to get an estimated blood alcohol level. Yannetti believed that the rearrest and the very high bail was all a ploy to scare him so that Karen would take a plea deal, which he said they would never have considered. Karen and Yannetti believed in this moment that this was intentional and she was being framed. Alan Jackson was contacted to join the team, and when he saw the injuries to John's arm, he said he immediately believed it was from an animal attack, not a car. So he said, if that wasn't true, what else isn't true? There are a few other takeaways from the article as well. One is a story from someone who said that her dog was attacked by Chloe, the Albert's German Shepherd that the defense believes is responsible for the injuries to John's arm. Now, the woman said that Chloe attacked her golden doodle while she was walking her, and she was unable to stop Chloe until someone came from the Albert's home and called her to stop. Her dog was covered in blood when she took her to the vet, and the vet said that it looks like Chloe was aiming to kill. The woman planned to report it to animal control based on the veterinarian's recommendation to do so, but when she called Canton Police Department, she was told that animal control wasn't there and they didn't know when animal control would be back. She left her information, and rather than hearing back from animal control, she and her husband heard from Kevin Albert, who was calling from Canton Police Department with a message from the police chief asking how to make this thing go away. That's not protocol. 3 months later, Chloe attacked another dog and then bit a woman who tried to intervene. And then, of course, as we heard at trial, Chloe was rehomed after 7 years of being with the Alberts. Another interesting tidbit, remember when Proctor testified that he was looking through Karen's phone but had to stop when he came to text between Karen and her attorney? There have been rumors on social media from the anti-Karen Reid group that have said that those texts included some type of admission from Karen to Yannetti that she was guilty of hitting John O'Keefe. But Karen says that it's an easily provable lie because her first contact with Yannetti wasn't until after the state police had already taken her phone and car. Now, we know that she Googled DUI attorneys right after Proctor called her and said that they were going to come talk to her. And Proctor was there about an hour and a half later. And this is on a Saturday during a snowstorm. And I checked Yannetti's website, and there are a few ways to contact him that are listed. You can email or submit a contact form on his website or call the phone number for a consultation. But there's no number listed to text him. So unless she made contact with him and he gave her his cell phone number and they began texting within that hour and a half, it looks like she's right. But phone records can prove all that anyway. Another very interesting part of this article is the infamous Jen McCabe Google search. Here's Miller.
I was able to find a forensic computer expert to look at the information that the prosecution's experts and Reid's expert had gathered. He came to his own independent conclusion, saying that the search did happen at 2:27 a.m.
Miller's expert is a PhD at Purdue's Department of Computer and Information Technology, and he specializes in iPhone artifacts and the limitations of digital forensics. He said that based on his research and expertise, he agrees with the defense expert, Richard Green. He says even though the browser tab was opened earlier than the searches, the timestamp for the search items is recorded and stored in the database, not the time of the tab opening. He also noted that Green also verified the search times with associated WAL files that are occasionally overlooked. Miller also spoke to a juror who expressed frustration about Jen McCabe's credibility on the stand. The juror said at times it became so frustrating that they wanted to just yell out, "Can you shut up? Tell the truth. Just tell the truth." McCabe's credibility has been a hot topic of discussion, especially since her cell phone records revealed the Google search at 2:27 a.m., hours before John O'Keefe was found. Another new piece of information is something that happened when the Alberts decided to sell 34 Fairview Road.
Once the house was sold, Karen's detective was able to get a hold of all the carpeting that the new owners were getting rid of that had been in the house when the Alberts owned it. Since then, she's been paying for a temperature-controlled storage unit to store this rug, this carpeting, in the hopes that she can one day swab it for DNA or for blood.
Pretty interesting, right? Proctor did not respond to Vanity Fair's questions. Neither did the DA's office, Higgins, Collin, Lally, Jen McCabe, Judge Canoni, or anyone else associated with the prosecution, really. Both parts are now available at Vanity Fair. As the new trial quickly approaches, both sides are keeping the Norfolk County court clerk busy with multiple filings. Now, these filings are important. This is laying out the foundation for the new trial, including what evidence will be allowed, what testing is able to be done, and what could be different this time around. An order came through that Judge Canoni was given special assignment to oversee this case, so she will be presiding over all hearings and the trial again, even though her role has changed, as mentioned in a previous episode. Also, in episode 30, I went over a filing from the Commonwealth where they said that they have a new expert who believes that the data retrieved from Karen Reed's Lexus was incomplete. Remember the whole megabytes versus megabits argument? Well, that was addressed along with various other issues on the docket. So let's go through some of them because these are all going to be incredibly important when it comes to the new trial. Let's start with that SUV testing. I mentioned before that the prosecution is asking for court permission to re-examine data from Karen's SUV. They say that they have a new expert who believes that data can be obtained from the SUV's computer chips. The defense wants their own expert present for any testing. Now, during the hearing, Brennan argued that some of the informatics data that was downloaded was unreadable, so their expert thought that it wasn't fully downloaded. There was the whole issue with their expert thinking that the gigabits and gigabytes or whatever were interchangeable or got confused. He says that he thought this because it was obvious to them that information was missing. That's what they're saying. So once the prosecution's expert realized the mistake on bytes versus bits, he says that they also realized the chips that were read from the car were read with the wrong reader, which is why he says the information wasn't available. He also says that they discovered the infotainment center has 3 boards, not just one. So he says that there are chips that haven't even been downloaded. Brennan also says that during the first trial, the Commonwealth's expert deferred to the defense's expert to do the data extractions, and Brennan claims that the defense expert is the one who overlooked the other chips and the fact that there were 3 panels. But he says their new expert found those oversights. Now, Jackson gets up for the defense, and he says that they have no objection to the retesting, but they point out that Brennan is misrepresenting what happened during the first trial. The Commonwealth's expert didn't have any idea how to do a chip-off, so that expert then turned to Gaffney, the expert that was present for the defense, and asked if she knew how to do it. He says that's why the defense expert ended up being the one who extracted the data. Jackson says that they have since added another expert who specializes specifically in the chip-off process. And given the fact that the prosecution's expert didn't even understand the bits versus bytes thing, they're concerned that further mistakes could result in destroying information during the chip-off process. So because of that, they want their expert to be present and to observe. And if their expert determines that whatever is about to happen is destructive, they want to ask that he be allowed to interpose objection and then contact both counsel and present those objections to counsel or to the court to resolve it. Brennan says that the defense isn't entitled to veto power and says that it'll delay the process. The process is another issue here, actually, because the testing takes 3 days and it takes about a week to read it. And right now they're saying that they can't do the testing until December 2nd, which Brennan says is too late, especially since their new crash reconstruction expert that they have hired will rely on that testing. Judge Canton ruled that the testing may occur, and if the defense wants their expert to be there, then they have to notify the prosecutor within 5 calendar days. The defense's expert can observe, but not intervene. Another thing that Jackson kind of fought back on was the issue that Brennan said where they used the wrong thing to download the data. He says it wasn't wrong, it was software that had not been fully developed yet. So Burla hadn't had the software out that could actually read the data at the time that they did the extraction. Now there is updated software that could potentially read more of it. We'll be right back after this. Another issue on the agenda for the new trial is the phone records of Karen's father, Bill Reed. The Commonwealth has filed a Rule 17 motion where they're requesting that the court order Verizon to turn over Mr. Reed's cell phone records. This includes subscriber information, all call records, text records, and data use from December 30th of 2021 through January 30th of 2022. The Commonwealth says that when Karen couldn't get in touch with John in the early morning hours of January 29th, that she made several phone calls, which included calls to her parents. Now, this is something we already knew. This was in her phone extraction, but they say that they now want the records and plan on calling Mr. Reed to question him about what they are saying are conflicting statements that were made by Karen on January 29th. Now, Brennan lists this interview with reporter Ted Daniel and Mr. Reed in his filing.
During your first discussions with Karen, did she believe she may have hit John?
No. No. She felt she struck something. She said, Dad, I think I struck something. I said, what do you mean? Right? This was in the hospital. Right? He says, I remember, all right, backing up and hitting something.
So here's the thing. Brennan quotes this clip incorrectly in his filing. He says that Ted asks Mr. Reed about his first discussion, and Mr. Reed says what Karen told him, clarifying that she said this while they were at the hospital. Brennan says the hospital wasn't their first conversation. They spoke at 6:32 a.m. that morning, according to Karen's phone records. And Karen wasn't admitted into the hospital until 7:26, almost an hour later. But Brennan quoted Ted Daniel wrong. Ted Daniel didn't ask about the first discussion. He said, during your first discussions. The implication is the initial thoughts, the initial conversations that you had with Karen about everything that had gone on. It's strange because Brennan acts like this is a gotcha moment that entitles him to the cell phone records of Mr. Reed, who wasn't even a witness. The defense filed an opposition to this request, calling it a fishing expedition and pointing out that any information that could be gleaned from his records is already available to the prosecution through Karen's phone extraction and records, which they've been in possession of since the start of this case. They also say that Mr. Reed wasn't present at C.F. McCarthy's, Waterfall, Fairview Road, and he isn't a witness to any of the relevant issues in the case. And he wasn't called as a witness to testify. And now the prosecution is seeking to invade his privacy by requesting his records for a full month. They also point out that they already know through Karen's phone extraction and records that she called her mom that night. None of the calls were answered, and the first contact that she made to her father was not until after John had been found in Brian Albert's yard. The Commonwealth wants to show that Karen calling her father in the middle of the night isn't usual for her. But there were no calls made to her father in the middle of the night, so these records that they're requesting have nothing to do with that. Besides, they have Karen's phone records. Prosecutor Hank Brennan said he filed a series of Rule 17 motions where he's requesting phone records, but he hasn't given notice to the third parties yet. So this wasn't actually argued at the hearing. Another hearing was scheduled for this in a couple of weeks. So basically what this means is that the Commonwealth is asking for these phone records, and Brennan, who is requesting the records, has to give notice to the parties so that they can have an opportunity to respond. This is kind of like when the defense requested the records of Brian Albert, and his attorney came and argued in court why it shouldn't be allowed. Now, something that's of note here, when looking through the defense filing that talks about the Commonwealth already having access to Karen's phone records, they include the application for the search warrants from Michael Proctor. Now, the warrant application is requesting all of the information that they wanted, but of course, applications have to be specific, so each part is listed individually. But here's what stood out. Proctor says on the application that he wanted the information between this person and that person, et cetera, from whatever date and time until 5:30 p.m. on January 29th when Karen's cell phone was seized. 5:30 is written multiple times, and the only reason that this really matters is because Karen's phone wasn't seized at 5:30. It was seized before that. Why is this important? Because the 5:30 time frame was given multiple times by the Commonwealth until ring footage showed Karen's car being put on the tow truck at 4:15, an hour and 15 minutes earlier than what they were saying. They then referred to the mistake as a scrivener's error, just a mistake. 4:15 looks just like 5:30 when you type it out or something. But here we see that they said it multiple times in the application as well. Part of the defense's theory is that Proctor got Karen's car and was able to bust the taillight that had the crack in it and then get back so that the pieces could be put at Fairview Road to be found by the CERT team who was about to go do the second search of the yard after Canton Police Department had finished theirs that morning and found no taillight. They found cocktail glass pieces, but no taillight. That hour and 15 minutes made a big difference in their argument. And here we now see it written multiple times as 5:30, which doesn't do much to support the scrivener's error argument. Also filed by the Commonwealth was a motion to get the phone records for Karen Reed's mother, Janet. Brennan says in a filing that they want to use Mrs. Reed's records as potential impeachment evidence, depending on the testimony of Mr. Reed. He mentions comparing the timing and frequency of Karen's calls to her mother on the night of John's death as compared to dates not involving an alleged crime. Again, all things that they already have access to through Karen's records. The defense also filed a motion for the sidebar conversations during the first trial to be made available to the attorneys and the court. The defense says that there are evidentiary issues and that they will be addressing them and would like these sidebars unsealed and available. Judge Canoni has ordered that the sidebar conferences be transcribed and made available to counsel in the court. Also, the Commonwealth has filed a motion to have all notes, recordings, emails, etc., basically anything and everything from the various media outlets that Karen Reed has spoken to. They want all of that. It appears that they're hoping to dig into all of this for evidence against Karen and to look for discrepancies in statements that she's made. Now, this includes Boston 25 News, NBC Boston, ABC, and Gretchen Voss for the article that she did for Boston Magazine. Now, the Commonwealth sought this before, if you'll remember, and they asked for access to Boston Magazine's communications, specifically with Gretchen Voss and Karen Reed. The court allowed access to the on-the-record recordings, but things were heavily redacted because they were not given access to what was said off the record. So now they're trying it again. A joint motion was also filed to postpone the trial. Both sides would like the trial changed from January 27th to April 1st to give both sides adequate time to prepare. Now, they mentioned the SUV testing that needs to be done and experts and forensic testing, etc. And both sides argue that it is in the best interest of justice, the defendant, and it is what is best to have a more efficient and effective trial. The first time they asked this, when Lally and the defense both wanted it delayed, Judge Canoni said, no, we're going ahead with this. So we'll see what she rules on that for this time. And finally, the defense wants email and phone records for DA Michael Morrissey. I had a feeling this was coming after the Bedrow letters. Now, the Bedrow letters were actually referenced in the filings, and they point out that the Commonwealth is in receipt of statements from a number of witnesses that were apparently withheld from the defense. They say that by law, prosecutors, including the DA, are required to provide all discovery to the defense, and using personal cell phones and emails doesn't shield the DA from that requirement. The defense argues that Marcy may have used his personal accounts to communicate with Stoughton District Court personnel and judges while Reed's case was pending in that court. And he used personal accounts to discuss information leaks in the case against Aiden Carney. Those were all mentioned in the previous episode. So since Marcy is using his personal phone and email to do official business, they want access to it. Brennan requested 10 days to prepare a written response. So this hasn't been argued in court yet, but when it is, I'm sure that will be interesting to watch. I'll keep you posted. It definitely looks like we're in for some big differences in this trial. Brennan's style is very different than Lally's. It felt like the majority of the first trial, the Commonwealth acted more as a defense for the Alberts and McCabe's as opposed to a prosecution for Karen Reed. Brennan also said that he intends to cut the witness list down, which I think we can all appreciate. I expect there to be a lot more updates on this case in the coming weeks as we prepare for trial. There are new filings pretty often now, almost daily sometimes, and there are multiple hearings that have now been scheduled in the coming weeks. It'll be really interesting to see how Brennan intends on shifting the focus off of the major issues with the case and where they go from here. Seems like both sides are still arguing that they want justice for John O'Keefe, and both sides still disagree on exactly what that looks like. My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.